recording.
All right, Keith, are you ready?
I'm ready.
Before we call it to order, after I do the roll call, I would like to make some announcements.
Okay.
All right, we're ready.
All right. We'd like to call to order this Thursday, December 17th, 2020 Alarm System Contractors Board meeting. Ms. Vest, you want to call roll?
Yes, thank you. Keith Harvey,
Here.
Scott Cockcroft,
Here.
Lou Richard, Doug Fraker.
Here.
Let the record show that Lou Richard is not present, but we do have a quorum. Thank you. Now that we've done that, I would like to go ahead, if possible, and make a couple announcements before maybe we better go ahead and adopt the agenda. I'm sorry. Let's go ahead and adopt the agenda.
Okay. Has everyone had a chance to review the agenda, and can I get a motion to accept it as presented?
Make a motion to accept the agenda as presented.
And second by Scott.
We have a motion and a second.
All right. Keith Harvey,
Yes.
Scott Cockcroft,
Yes.
Doug Fraker.
Yes.
Motion carries. All right, before we get to the rest of that, I just wanted to make the announcement that Ashley Thomas is no longer our staff attorney. If you're looking at your video, you see that Jesse Gentry is with us. Jesse is now our staff attorney and our litigating attorney, and I believe that title is going to be Associate General Counsel, and we are pleased to be able to keep Jesse with us. So thank you, Jesse, for taking on both of these roles. We appreciate that.
Yes, absolutely.
Of course, thank you.
Lou's sending me a message here. Yeah, he's having trouble logging on. We have a new assistant commissioner by the name of Alex Martin. The former assistant commissioner was Toby Compton. He's now our deputy commissioner. And we have a new commissioner for the Department of Commerce and Insurance, Carter Lawrence, who was the deputy commissioner. So I just wanted to get those announcements in there before I forgot. All right. I think now we're ready to move on to the minutes.
Okay.
You don't need to do the statement of necessity first.
Okay, yes, I wrote that down and forgot it. Okay, go ahead. Yes,
Okay.
please.
Okay, perfect. Pursuant to Tennessee Code Annotated Section 844-102, this is a regularly scheduled meeting for the Tennessee Alarm Systems Contractors Board, which is taking place via video conferencing means pursuant to Governor Lee's Executive Order Number 16 and extended by Executive Order Number 65. Meeting remotely is considered a reasonable measure to protect the safety and welfare of Tennesseans while ensuring government business may continue in a manner that is open and accessible to the public. All votes by the board will be by roll call. Notice of the meeting date, time, and location has been noticed on the Tennessee Alarm System Contractors website since September 30th, 2019, and this month's agenda was posted on December 10th, 2020. Pursuant to Tennessee Code Annotated Section 844-108B2, if a physical quorum is not present at the physical location of a meeting of a governing body, and in order for a quorum of members of the governing body to participate in the meeting by remote means, it may be accessible if a necessity exists and a statement of necessity is read into the record. The determination must include a recitation of the facts and circumstances for which it is based. A necessity is determined by matters to be determined by the governing body if it requires timely action. A physical quorum is not practical within the time requiring action, and that participation of a quorum of the members by electronic means is necessary. The purpose of today's meeting is to discuss the meeting agenda, which was previously posted to the board's website, and all voting, again, will be done by roll call.
All right. Thank you, Jesse. Appreciate that. Now, Keith, if you'd like to go back, we'll do the minutes.
Okay. If everyone has had an opportunity to review the minutes from October 22nd meeting, could I get a motion to approve those minutes?
I make a motion to approve the minutes as presented.
Doug Fraker, second.
We have a motion and a second.
All right. Keith Harvey,
Aye.
Scott Cockcroft,
Aye.
Doug Fraker.
Aye.
Motion carries.
Okay. On to the legal report.
All right, thank you. So we don't have a lot of cases on it, but we do have some very detailed ones. So we'll start with number 1, which is case number 202054971. The summary is that the complainant was visited by one of the respondent's door-to-door salesmen on or about June 3rd, 2020. The complainant stated he had an alarm system with a different company, and that respondent salesperson stated, 1, the complainant was due for an upgrade, and 2, the respondent's company was buying out the complainant's current alarm company's contracts. The complainant then stated the salesperson told him to stop making payments to the previous alarm company, and that the salesperson would mail off a letter to the complainant's other company to pay off any remaining balances. From an additional investigation of this salesperson, his application to become a registered employee was not submitted until July 22nd, 2020, and was not granted until August 10th, 2020. Although we did not make contact with this salesperson, it appears the respondent was sending him to work prior to him becoming registered, as well as prior to submitting his application to become registered. The complainant later received calls from his previous company, which told him it was not going out of business and that he was still under contract with them. The complainant further stated that he never signed a contract with the respondent, but later found out he was locked into a 5-year agreement with the respondent. The complainant did not have physical copies of the contract from the respondent in his possession. He did have a blank pamphlet with some scribbling on it, but the paperwork he had lacked signatures and contract details.
Can you go Wait.
Do you need to wait?
Oh, no, go ahead. I'm sorry.
No, you're fine. Our investigator was able to get an electronic copy of the contract from the respondent, and it had electronic signatures from the respondent and his sister, who is the property owner. Our investigator showed the contract to the complainant, and he denied the signature being his. He denied having signed anything on any type of tablet or otherwise, and denied his sister's signature on the contract as being accurate. The complainant stated he hadn't seen his sister in over a year, as she was elderly and did not get around much. Our investigator tried to get in contact with his sister, however, she stated she did not want to be bothered. The respondent also provided a recording with the salesperson and the complainant, in which the complainant acknowledged that the respondent was not affiliated with any other company. The video also asked the respondent whether he had any other contract with any other alarm companies, and the complainant clicked no. The respondent has stated that the complainant knowingly entered into this contract, and that the contract terms should be honored, including any early termination fees of the contract. The video does not show the contract and its terms being disclosed to, or the documentation with the complainant, and the documentation the complainant did not fully disclose the terms of the agreement with the respondent. To date, the respondent has not paid off the complainant's previous alarm contract, as it stated it would during the initial meeting. The respondent's representative our investigator spoke with also acknowledged this would be done. However, he wanted our investigator to provide him with the complainant's contract information for the previous company. Additionally, the complainant has also been approached by a third company salesperson and has signed a contract with this company now as well to have monitoring from them with an outdoor doorbell camera, which was installed by the complainant's back door that appears almost inaccessible as it's on a porch covered with items. This salesperson allegedly told the complainant its equipment was of higher quality, and that the respondent's equipment, although most of the features for the doorbell camera are not applicable to the complainant, since he has a very basic flip phone. This behavior of the complainant shows a concern that he may not have the capacity to enter into contracts or actually understand the terms of these agreements he's entering into. These facts show several violations by the respondent. First, the respondent's salesperson was not registered at the time he sold the system to the complainant. Second, the respondent salesperson made statements that were in violation of the board's rules. Third, the respondent has no proof the complainant or his sister were provided with a copy of the contract at its execution, as the complainant stated he did not receive it until our investigator gave him a copy of it approximately 4 months after it was signed. Fourth, the complainant alleged he did not sign the actual contract. Initially, this seemed as if it could have been the result of confusion on his part, as it would have been surprising for a salesperson not to at least have the complainant sign something electronically. However, the fact that the complainant's sister's signature was also added to the contract and she does not live with the complainant nor has the complainant seen her in over a year, is extremely suspicious and bolsters the complainant's allegations that the respondent had fraudulently added his signature and his sister's signature to the contract. Additionally, unlike the complainant, there was not a video recording with the sister showing where the salesperson met with her. Therefore, the recommendation is to authorize formal charges with a settlement offer through a consent order and a $5,000 total civil penalty as follows: $1,000 for having an unregistered employee with access to sensitive information pursuant to Tennessee Code Annotated, Section 62-32-312, and Tennessee Code Annotated, Section 62-32-304K. A $2,000 penalty for violating provision of the board statutes for engaging in misconduct pursuant to Tennessee Code Annotated, Section 62-32-319B, 2 and 9. $2,000 for violating the standards of conduct and ethics pursuant to Tennessee compilation of rules and regulations 0090-06-.03, and for violating the rules of contracting with customers pursuant to Tennessee compilation of rules and regulations 0090-06-.04. So it'd be a total of $5,000 broken up as stated.
Hey, good morning, everybody. This is Lou. I'm sorry I'm late. I'm on mobile. I couldn't get on the WebEx.
All right, Lou, thank you. I see it's caller, probably ask him, call in user number 2. Excuse me, but let the record show that Lou Richard has joined the alarm meeting. I think we're up for discussion now about this complaint.
Yes.
Some of the key things for me on this were that like you'd said, the employee had not been registered, but also they hadn't even applied within the 30 days.
Mm-hmm.
The signature by the sister that wasn't, or hadn't even been on site for a year. And then the respondent did acknowledge, this is a question, the respondent acknowledged the contract that they would pay off the contract.
They stated they would pay off his first company's contract. Any early terminations when they, I guess, bought out that one. They want
that does sound like that lends some credibility to the complainant.
I think so too. It's they still want him to pay any early termination fees for their services, but they did state that they would pay off his first alarm company contract as long as they provided. Well, actually, the salesperson initially said that he would get it taken care of. He never took care of it, and then I believe he's a vice president that we spoke with. He told us that he wanted our investigator to give him that information, and he would try to get it taken care of. And to date, that still hasn't been taken care of.
Okay.
Any other discussion or thoughts?
It sounds to me like this goes right to the heart of a lot of the rules that were added that related to door-to-door sales.
I would agree.
Well, I'll make a motion to concur with recommendations of council.
Doug Fraker, I'll second.
We have a motion and a second.
Excuse me. All right, we'll take a roll call vote on that. Keith Harvey,
Aye.
Scott Cockcroft,
Yes.
Lou Richard,
Aye.
Doug Fraker.
Aye.
Motion carries.
All right, thank you. We'll move on to number 2, which is complaint number 20200572251. The summary is that the complainant entered into an alarm monitoring contract with the respondent in December 2018 through a 36-month contract. Since then, the complainant has had numerous issues with the respondent's equipment and had tried to cancel the contract without penalties. The complainant stated that when he first got the cameras from the respondent, the batteries were dead, and he had to pay $160 to replace the batteries in each camera. Then the cameras were not working properly, and the complainant had to pay an additional $50 for a Wi-Fi extender. That did not solve the issue, and it took the respondent several weeks to send a technician to the home to assess the issues. About a month later, the complainant was sent new cameras to swap out from the initial ones the respondent had sent. Soon after that, the respondent had issues with the cameras inside the home and was cited by the local police due to the complainant's alarm system sending numerous false alarms. Respondent did eventually send a technician to fix these issues. July 2020, someone tried to steal the complainant's vehicle from his driveway. The complainant had two cameras focused on the driveway, neither of them recorded anything occurring. The respondent sent out another technician who adjusted the sensitivity of the cameras. The complainant stated the cameras will now record sporadically. However, they also save over the previous day's recording each time. The complainant contacted the respondent about these issues again, and his response was to have the complainant purchase 4 new cameras for a total of $1,200. The respondent did not respond to the initial complaint, nor did it respond to our investigators' numerous requests for information. The complainant stated he has canceled has called the respondent many times. His quote was at least 100, end quote, and that he had rarely gotten through to customer service. He also stated the respondent has sent technicians to his home approximately 20 times, and these issues have still persisted as the complainant will periodically monitor the system from his camera and has noticed it's not picking up any motion. Respondent has had other complaints against their license, which were closed without action, although they'll also have numerous complaints with the Better Business Bureau. The recommendation is to authorize formal charges with settlement offer through a consent order and a $1,000 total civil penalty for violating provision of the board statutes and engaging in misconduct, gross negligence, and or incompetence pursuant to Tennessee Code annotated section 62, 32, 319, B, 2, and 9.
So the respondent is actually still licensed.
Yes. Their license expires at the end of December 2020.
Okay.
This is Lou. I make a motion to concur with council's recommendation.
Second by Scott.
We have a motion and a second to concur with council.
Okay, we'll do a roll call on that. Is to agree with council. Keith Harvey,
Aye.
Scott Cockcroft,
Aye.
Lou Richard,
Aye.
Doug Fraker.
Aye.
Motion carried.
All right, thank you. We'll move on to number 3, which is complaint number 20200074261. The summary is that the complainant contracted with the respondent in July 2020 to have an alarm system installed by the respondent. The complainant stated to the previous owner of the home, that the previous owner of the home had a different company and the complainant wanted to use the respondent's services and equipment. The complainant stated he felt like there were miscommunications with the respondent and that he did not receive the equipment he discussed with the sales agent. The complainant made this complaint and requested the respondent cancel his contract. The respondent responded to the complaint and agreed to cancel the contract and the complainant's obligations. So the recommendation is to close.
I'll make a motion to concur with council will close.
This is Lou. I'll second.
We have a motion and a second to concur with council and close the case.
Keith Harvey,
Aye.
Scott Cockcroft,
Aye.
Lou Richard,
Aye.
Doug Fraker,
Aye.
motion carries.
All right. What about appearances?
Yeah, but that was the end of our legal report. Yes, we have an appearance today. Mr. Braun, are you out there? I see your name came up, and I may be me mispronouncing your name.
No, you pronounced it right, Cody. I'm here. Thank you for inviting me.
All right. All right. Thank you, sir. I'm going to present this information to the board now. Everything was sent out to the board members to look at. This is turnkey technology. When they first wrote to me, they asked for the exemption. The exemption was going to be the fact that they had over $50 million in sales. So we started the process, and as it went through, it stopped because they could not at that particular time show me proof of the $50 million in sales, or withdrew it saying that they had not made that much that year. All right. So there was this correspondence going back and forth here with this. I hope everybody had an opportunity to look at all this information. This is an IP-based wireless network, or that's what they were turnkey demonstrated, an IP-based wireless network for Kingsport Metropolitan Housing Authority. Since they didn't fall under the exemption, I'm saying they needed to get a license. They need to be registered. Some more correspondence as we go through here says that they wanted to go into an agreement with another company to do their business, the alarm business. But as the statute reads, I believe it says both parties have to be licensed in order to go into a contract. So I'm going to turn this over to Mr. Braun and let him tell you what his company does, give you a better idea, and then we can talk about it further.
Okay, thank you, Cody. Turnkey Technology is a data infrastructure company. Excuse me. And by that, I mean we work with low voltage, non-110, 120 volt power. We install data lines. We build wireless networks. And the system that we had proposed to Kingsport is a wireless network that resides on the outside of the buildings. There's no internal wiring. It's all wireless, and it goes through the internet. And the system that we demonstrated to them also allows you to add cameras to it. And executing the contract, after we were awarded the bid, because Kingsport felt that the cameras would solve a lot of their issues that they were having, it was made kind of clear to us that under your Tennessee law that cameras on a wireless network could be and are classified as potentially alarm driven. And then that brought us to where we are today in trying to get an exemption for doing the work there. This job would basically be all outside. The only interior would be that bring the antenna and plug it into the switch that's internally. Turnkey does not do electrical. And under the exemptions, we saw that number 12 really applied to us except for the $50 million mark. So we were asking you guys if we could have an exemption based on number 12's criteria and parameters. And if that wasn't the case, our president was another road that we were looking to possibly go down that might be better for you or for us. The first exemption did not warrant such motion to pass, is that he's an RCDD, and we were hoping that maybe we could get an exemption based upon that criteria to become our registered agent, and then us moving forward that way. So those were the two solutions we were looking to you to approve for us to be able to put this job together for Kingsport. Does that make sense to you?
Yes, this is Scott. I follow what you're doing. A lot of what you're talking about. I mean, it sounds like you're relating to the wiring, and even licensed companies are not dealing with 110. And we're not regulating any high voltage wiring. It is about the installation. I mean, it's about the people more than it is really the installation. We really register people and companies. We don't oversee the installation. We do want to see that they've had some training. And personally, I would accept Big C for the registered employees training, but then the company still has to be licensed. And I would think we would probably accept the person's experience in data wiring as well, me personally anyway. So I wouldn't see a problem with getting the person as far as being a registered employee, but the company still has to be licensed for the registered employee to be able to do the work for you in Tennessee.
Yeah, is this the registered agent you're talking about? My name is Rick Brunsman. I'm the director of business development.
Oh, that's true. That's a registered employee, not a qualified agent. And it probably wouldn't be sufficient.
So an RCDD, which is the highest cert available for low voltage, would not qualify?
Well, it might. It's a certification for data wiring. It is not.
It's a certification for all low voltage wiring.
I don't know that it has any training in the alarm industry or in the.
Well, guys, the issue we're getting here is we're building a data network. All right. And it's going to be used for other things, cameras being one of them. Wi-Fi network for the users in the development is another. And it seems like the attorney that has looked at this has said to us that, hey, Tennessee's version of alarm is a camera. And we said, so basically, if I build you a data network that like we're using right now with this camera, and it's used to deter theft or can be used to deter theft, that it's an alarm and you need a license to install it.
That is correct.
Yeah. So what we've run into is this. Tennessee won't allow the highest Bixby cert for data low voltage cabling to qualify, and there's no cert higher. Yet they want us to meet some lower standard that our technicians will never ever install or use or do. And for example, I went and looked at the test. The test talks about RG connections and terminating coax cable and those types of things. We don't even sell those things. We don't even supply those services and never have. This is a data network, and those things went out of data networks 25 years ago. So the problem is, from an employee training standpoint, is we're going to have to train our employees on a whole bunch of things that they're never, ever going to do.
Which training are you referring to?
Well, there's the training to become a technician. I've actually gone out and looked at that test. And then the training to become a registered agent, or the qualifications to become a registered agent. I've gone out and looked at that.
And specifically, though, I mean, the tests are third parties. I mean, there's a number of tests that are approved. Which one specifically are you talking about?
Well, as I understand the Tennessee law, we would have to be under the CCTV license.
Right.
And if you go out and look at that test, it's an old closed circuit television test. I mean, it's stuff that we haven't done, we've never done, and don't do, and would never sell. We sell data networks, we do IT infrastructure work, and we have a customer that wants to put cameras on that. IP cameras. These cameras, why we call them cameras, they're basically little computers. And they do things like facial recognition, license plate reading, that kind of stuff. So we looked at different ways to accomplish this. And the easiest way is we were just going to sub it out to a licensed contractor. But that ran into problems because the company that buys this from us, the customer, gets a warranty. And they don't want, they're worried that, and rightfully so, that if something happens to our subcontractor, what happens to their warranty? And so that ruled that out. And then, so the next step was, well, let's just get certified. And then we ran into the registered agent problem. And then we started the steps to get technicians certified, and we bought the books and all that stuff. And we looked at it and we said, my God, there's all these things that not only do we not do, we're never going to do. And we're not in that business. We don't sell alarms. We don't sell alarm monitoring. We sell data networks. And so that ran into that problem. It was going to be very expensive to get them trained for something for one customer. So the next step was looking at the exemption list. And we do meet one of the exemptions, with the exception of the $50 million in sales. We do not meet that goal. So Verkada does, though, our manufacturer. And Verkada is willing to be the frontline player here. And then they would literally, because we're a Verkada partner, we have a contract with them. We would have to get them approved as the exemption. But that runs into other problems because this is a bonded project. And I don't know if Verkada would be able to get a bond or willing to get a bond. So everywhere we've gone, we sort of run into these roadblocks. And so we thought the easiest way would be just to get certified. And then we ran into the registered agent problem, and we thought for sure an RCDD, which is the highest cert you can get in low voltage cabling, period, and that includes CCTV, would cover that. And we were pretty stunned when we found out it wouldn't. So that's our conundrum. And the bigger problem is you have a customer that wants this product, and we're the licensed reseller on it. And there is a very good chance, if we can't find a solution, that we're going to have to tell them they're not going to be able to have this network.
And the main issue would be the installation of cameras on it. It's not the installation of the wireless network itself.
The cameras are as simple as plugging in a telephone. I mean, it literally has a RJ45 connector on it, and you plug it in. That's it. You don't do anything else.
Well, I would differ a little bit with that. I mean, there are...
Sir, I can show you a demonstration on the website how you install one of these.
I personally install cameras, but I think to narrow down a camera installation to just plugging a camera in.
Sir, we're running these wirelessly. These camera installations.
Okay, let me, if you could, just give me a moment to expound on that. The reason, technically, as far as the installation of the camera, yes, it's just plug it, you can plug it in, it gets power, it'll power up. But there's other items that relate to the application of the product as far as what it's going to see, when it's going to see it, how it's going to see it.
No, sir. These cameras don't work that way. That's not true.
So your cameras don't have to be pointed at something. Your cameras aren't affected at all by low light or no light.
Sir, they're not.
Your cameras are magical. They see everything.
They're not magical,
everywhere.
Sir, but they are very expensive. And these are, a cheapest camera I sell is $1,000.
Well, it sounds like you should definitely have someone licensed to install a $1,000 camera then. But a lot of it.
Well, the problem is the licensing process doesn't apply to what we're doing. In other words, it's the equivalent of asking a surgeon to get a carpentry license. Yeah, he uses a saw, but he's a surgeon and he has his own license to be a surgeon.
We're just going to have to agree on
many other things, but closed circuit television, we have never sold closed circuit television ever. There is a technical difference between that and what we're doing. We're running an IP-based network.
The definition, as far as in the law, it's not. It doesn't relate to the fact that it has to be wired or that it is a
Right. I understand that.
No,
I understand.
I don't think there's any companies probably that are installing what used to be called closed circuit. If you want to go back to the definition of CCTV, and it's
and we learned that through legal that what Tennessee considers an alarm, and so that's and we are willing to get certified if they'll accept the RCDD as our registered agent. In other words, if that will, he'll go through the whole process. He'll take the test. He'll do all that stuff. But and he has 10 years of experience in this field. We've installed thousands of cameras. But anyway, if you guys will accept that as valid to be the registered agent, we'll go through the process.
Why would you not? Why would so the person does not already have Bixby? Is that correct?
He does. He already has it. He has a Bixby cert in RCDD, which is the highest cert you can get. It covers everything under Bixby.
Okay, because you said something about you would get the person certified in Bixby, because I was just questioning why.
No. He already has the certification. He's been Bixby certified.
Okay, because my question just was going to be, why would you not take one of the other courses that are already approved? It could be done in a weekend.
Would that qualify as the registered agent?
For the qualifying agent, yes. There's a number of classes that can be taken in 2 days.
Yeah, if that's the case, if we can take a 2-day class to qualify as registered agent with his history and his RCDD, I think that's very doable on our end.
Can I inject here? Under would they not fall under 6232-313 C3? The applicant must hold current certification by a nationally training program approved by the board. I think that's what you're discussing right now, and have at least 5 years experience in the business, which sounds like he does. Would he not fall under that for the qualifying agent?
For the qualifying agent, or with the qualifying agent?
I beg your pardon?
Were you saying, would he qualify? Would he be?
Yeah, would that qualify him to get the application?
I don't think Bixby's ever been submitted as a test for qualifying agent. I guess, we could go through the process of submitting it for education for approval.
That's a chore in itself right there, and time as well.
It has come up before. There have been other people that have asked about Bixby, and it hasn't been accepted in the past, but it's never been submitted as an actual training class.
Okay, let me ask Mr. Braun, are we saying the gentleman that you would fill out the application doesn't have a 4 years bachelor's degree in electrical engineering, industrial technology, or doesn't hold a degree in engineering technology?
Correct.
He doesn't have any of those, so
No, he does not have an engineering degree.
All right, so it'd fall under number 3 then, if we accepted the RCDD or whatever that course is.
The RCDD it's a 5-year program. The stuff that they teach you there, a lot of it does fall and is taught under the engineering degree.
If it was approved, you wouldn't have to have any of the other engineering degree stuff. I think Ms. Vest was just bringing that up because that was another route.
Okay.
It's not anything about Bixby, because Bixby on its own would stand as the training if the Bixby training was approved.
Okay.
I don't think it's ever been submitted, so we don't have as far as what the testing, whether it's proctored or not, or how it goes. I'm somewhat familiar with Bixby, but I don't know the whole testing process or what goes into it.
This is Lou. So as I understand it, from what I'm hearing, The RCDD you've got has got the experience. He's got the credentials. And all he has to do now is just take a two-day online course and take the CCTV exam, and it sounds like this would be solved. Are you guys not willing to do that? My question's to the turnkey.
Oh, yes, we would be, yes, we would do that.
What kind of a turnaround time are we talking about here for your contract, turnkey?
Well, we would like to have this done. They were looking for January. I mean, right after, mid-January, which we know will have to get pushed back now if moving forward. So the sooner the better. I mean, if you guys approve and allow the Bixby to be the credentials, we'll get moving on it on our end as quickly as possible. And I know with the holidays, that kind of throws a little bit of a wrench in it, but
right. I know the testing institution, the facility is already full for January.
Okay.
We'd have to make a telephone call, see if we get, and then it's where are you going to do it at? Are you going to come into Tennessee to do it? Are you in Tennessee? You're in Ohio.
We're in Ohio.
Yeah, it's going to have fingerprints done. I mean, this is not going to be fast.
No, I understand that.
We probably could get it done with a few phone calls if we can by the end of January, but there's not any way we can do it before.
Okay.
I mean, if it was us, it was just a matter of pushing a button, but we're talking about having to deal with other places.
Sure, I understand.
So what is the board trying to tell me? We're saying that we would accept that as the training, or they're going to make application, go out and do a 2-hour course or 2-day course, whatever, going to do go take the CCTV test and then do the fingerprinting as well and get a license.
I believe that's what Lou and I are
okay. I'm just,
and this may still be frustrating to the applicant, but Bixby really is still not coming into it. It's what we're talking about is just taking one of the approved tests,
okay,
and going through the process. I understand the frustration that Bixby may seem sufficient. It just isn't an approved course currently, and I don't know that we can accept it. The other avenue would be for them to hire a qualifying agent, which I know does not probably seem like that makes sense, but that is a legal way for them to move ahead sooner. I don't really like that idea, but that is an avenue. That's probably their quickest avenue to get licensure and to move forward.
Okay, let me explain that too. Simply what he means is the company would make application. They would already, whatever agreement you made with the qualifying agent, would move him over from wherever he is, if he's independent or she. And it's just a matter of pushing some buttons. You qualify and the company's up and running. I mean, you're talking about, what, 48 hours?
You have an approved list of qualifying agents that you could share with us that we could contact, or how do we go about finding a qualifying agent?
Yeah, so we have a website that has our qualifying agents on it. We would share that with you, of course, and you can go through verify, but you'd want to, you'd probably have to make some telephone calls because we don't keep a list of what we call independent. But I do have some that don't have company affiliations. As far as your employees are concerned, they don't have to have the employee testing for at least a year of their employment. So all they have to do is make application, pay the fee, do the background check with the fingerprints. So that they're pretty easy to do. So I don't know how many employees you would have.
Mm-hmm. Could be a few. I mean, we just have
just a couple. Okay. Well, those are real easy to do.
And you probably could, if you had most of your employees working on the wireless network and not actually installing cameras, would probably be the easiest route.
Okay.
And there are some other lists beside the list that Cody's talking about would probably be harder for you to find someone just because it's a list of everybody. Some of them couldn't qualify for you because they're qualifying for another company. There are some sites on the web that have, they actually sell contracts and different stuff that would use between you and the agent, and sometimes they can refer you to someone.
Okay, so that's the short-term solution. Long-term solution with the BISBE, is there any chance that that will become a qualifying component for us to get our own registered agent?
Yes, they would have to submit the course to us, give me all the information. We have steps that I can explain to you, to them. And then, of course, that has to be brought back before the board again to be approved. And I believe you meet in February, do you not? I think that's when your next meeting is in February.
Right. Is it an issue
So,
with him presenting or him submitting it versus, because you have to have the company or the trainer?
we
This is
would
what
like, yeah,
Cody
we'd like to have the facility, the company itself submit the documents.
we've had
But
people, we've had people submit something for just for themselves in the past, I think, on an individual program. I guess maybe that was more for CEUs. We had someone that took a
yes.
class and then they want to submit it for CEUs. I'm not trying to make this more difficult. I'm just trying to make sure we get him all the information, but it sounds like they
Right.
themselves would actually need to submit it.
Right.
They've got to
That's who
submit the trainer as well, which it would be in their, you know, it would be a good thing for them to submit because other people would use it. But it may be hard to get them to do that. I don't know.
Okay. So just so I understand the process here, we need to go out onto your website, find and hire a qualifying agent. And then do we contact you at that point? Is that the case? Is that this process?
Well, if that's what you're going to do after this telephone call, I mean, after this board meeting, we can meet in a
Okay.
telephone call, and I
That's
can
fine.
help you, guide you through that.
Perfect. Perfect.
Because he could go ahead and start the process of the company application and all that.
Yes.
Even without the QA. So.
Right. All that can be done without the QA.
Okay.
And the registered employees too will give you the website and
Okay.
just help you all the way through that process.
Cody, I'll reach out to you. Are you available this afternoon? And
Yes.
I'll circle back with you then and
All right,
take
that'd
it
be fine.
offline.
We'll
Okay.
just go from that. You and I are just this is Mr. Braun, right?
Correct.
All right. Yes, we'll work together on this.
Okay. Okay. Thank you.
Thank you.
All right, so that's where we're at with this. We're going to be working with Turnkey Technology to help get them licensed and as quickly as possible. All right, very good. Let's see, and I don't believe I need a vote on that. Let's see, what is the next thing? Let me put my stuff away here. We're going to move into our. I think we're going to move now, Keith, into my items for the administrative matters.
Yes.
All right. So let me just make sure I've got this right with Turnkey. I'm going to, the gentleman's going to call me, Mr. Brown's going to call me afterwards, and we're going to work it through the quickest way possible, in which sounds like they may have to go out and get an independent qualifying agent. And Scott, I do believe, if I'm correct, I may be able to go out on the website myself and try to find one who doesn't have a company affiliation. Unless they want to go the other avenue. Am I correct here?
If you can do that, that would be great. I didn't know if you had the ability to do that.
I believe I can. I'll do my best anyway to assist them and try to get them up and get them running as quickly as possible. But you know, I don't have anything to do with the fingerprinting or with the exam that the gentleman needs to take. And I think you're telling me he needs to take the CCTV exam only.
Right.
Okay.
Right. That's the only one he would need to.
All right. I want to make sure I got all this right. All right. Then we'll just move. I beg you. Go ahead.
I was just saying, this may sound odd to him, but I've never seen the CCTV exam because I wasn't on the board when it was created. So
He hadn't either. If he has not set up an appointment to go take the exam, he hasn't seen it either. So he may be talking about the contractor's board. I don't know.
okay,
But
because I
if
just
our exams are not out there I hadn't even seen it.
well, and I don't know. I mean, he may be right. There may be very outdated stuff on there. I don't know if that's
Well, we're going to be working with Prometric on that. They have contacted me several times, but I've held off on doing the exam so I can determine what's going to happen on the hill. If that
okay.
makes any sense. I didn't want to put everybody through all that
Right.
and to that expense. It is expensive to do that. Yes, but we will be looking at all those exams again.
Okay.
Yes. All right. All right. Just want to make sure I was correct. Okay, we'll just move on to mine now. Administrative matters, my monthly report. There's really not anything to report there. We still have a vacancy. And I understand that they're still working on that. This public member vacancy. We had our board meeting in October by WebEx. I met with the it says Assistant General Counsel Ashley and Jesse. Well, we talk almost actually daily, but we do have a date down there. And then now we will be meeting monthly, and we will have a date for that. I got the financial meeting. I met with the Assistant Commissioner, which was Toby Compton at the time. I haven't had any media contact or market outreach. And on this one here, this for October, we only had 8 complaints, and you heard, I believe, 3 of them today. So that left 5. All right. Our next topic here is going to be your budget. Well, I'm kind of pleased with this after everything else that's happened. Let me get this. As of the end of September, you got $34,645 to the good. I just wanted to go back and give you because we haven't. I may have already done this at the last meeting, and I apologize if I'm repeating myself, but I want to make sure you do know what we have here. Our year end for alarms, you ended up with the year end total of $52,215. I don't think we've ever worried about having too much money there. It's on the reserves. Your reserves right now are, let's see, remove this one. The reserves right now are $2,345,000 and looks like $28. We have I've signed off on the contract for the new printers in our department. The around $30,000. I think it's probably going to be a little bit more than that, but that was around $30,000. But it will be divided between the other programs as well. So there will be a charge to you whenever that comes in. But as you can see, we are maintaining for as the budget's concerned. We don't want to make too much, but we got to make enough to keep operating. When we sit down to do these exams, I think we're already into the 3rd year. Those are $5,000 a piece. There will be an expense to do that, but as it is now, I believe we could probably do that like we're doing now through WebEx, but we'd have to see. If we don't, we have to pay for them to come in, go to her facility, have to pay you. So there would be an expense in that, but I'm not looking at that right this minute. Legislative update. I don't have any. Do you, Jesse?
I do not know.
Oh, I will tell you, I have talked with Penny Brooks with the association, talked with several people, and they may be running some legislation this year. They've already going to be starting. We're up there. I believe the new one starts in January, if I'm not mistaken. So I understand that they've been talking to their lobbyists, and they're going to be trying to run. I talked with her briefly, but I'm not in a position to tell them what they need to do, don't need to do. It's a little harder for us to do that, but I just hadn't heard anything from the Hill or from our management to tell me what we're going to do, but I'll keep you up to date as soon as I hear anything. Request for extension? No, we don't have any. So we're going to go down to criminal histories, and they're rather interesting today. So we're going to go ahead and start. Hopefully you've looked over everything. You got all the material to look at except the fingerprint report. Everybody knows, and I'm going to make that statement. Everybody knows we do not send you the FBI or the TBI reports. But anything that the applicant sends us is considered public record, and therefore you get to look at that. So let's just take this first one, if you would, Aaron Morris. These are registered employees, by the way. This gentleman here is trying to go to work for a large company as a technician. This gentleman here was in the military. He got an Article 121, an Article 129, and an Article 130. And he was found guilty, and he got a special court martial for a bad conduct discharge. That was in 2008. You have with you there, or you should have, his charge sheet. You're going to have information for the court martial is what you have. And hopefully you've had a chance to look all that over. I want to know if you have any questions on that. He does have some references there. Sean, are you out there? Shauna. I know it shows that she's on there. I don't see that I have his
Yes.
letter of Okay, I don't see where I've got his letter of explanation.
Let me check his file real quick. Hold on.
All right, thank you.
Uh-huh.
While she's doing that, I told you it was Article 121, which is larceny from a military property. Article 129 is a burglary, and Article 130 is housebreaking. He was found guilty at a special court martial, received 10 months confinement. They reduced his pay by 2/3. For 10 months, reduced him to a rank of E1 and issued him a bad conduct discharge. Do we have any questions, commission members?
And from what I'm reading, this is just 2 years ago.
Yes, sir.
I don't have any questions.
Okay, if we
I've already made my mind up.
Okay. If we approve, that's fine. If we do not approve, we will have to go to the Fresh Start Act. Jesse, do you have your copy? We'll have to go to the Fresh Start Act.
I do.
And you would have to say why you would literally deny. Just in case you do, I'm just telling you, we'd have to go to that.
Okay.
Cody, I don't see any explanation in his file.
Okay. He just let the record stand for itself then. Jesse, I think we're looking at, according to me, the second page there, 4A, 1, 2, 3, 4, 5, 6, and 7. All right.
Now I'll read. Do you want me to read them and have the board members discuss which factors they're saying it falls under?
Well, let's find out. Only person that said anything was Doug.
That's
Does
true.
any other board member have an opinion or question or? want to guide me in which way to go?
I'm kind of with Doug.
All right, Lou, how about you?
I'm like Doug. I've got my mind made up.
All right, Scott?
Yeah, I don't have any questions, but I guess somebody going to make a motion?
Yes.
Oh, well, I'll make a motion that we deny this application due to the short time frame that this happened, just being in 2008, and for the type of violations, the theft.
This is Lou. I'll second.
All right. You've got well, I just wanted to let you make sure you knew I think I said it, he's going to be a technician, so he would be going in people's homes, I'm sure.
Oh, yeah.
Okay. Let's go ahead and Keith, want to go ahead and let's get a roll call on this?
Yeah, we have a motion and a second. Get a roll call.
All right. Keith, the motion is to deny. Keith Harvey?
Aye.
Sorry, that was my telephone on the desk. When I go to the store, I know when my phone rings. Sorry, didn't turn it off. I apologize. Keith Harvey.
Aye.
Scott Cockcroft.
Aye.
Lou Richard.
Aye.
Doug Fraker.
Aye.
Okay, the motion has it to deny. So now, Jesse, if we would look at the Fresh Start Act, please.
So in considering whether to deny an applicant for a license, certificate, or registration to an applicant, or whether to refuse or renew a license, certificate, or registration on the basis of a criminal conviction, the licensing authority must consider the nature of the seriousness of the crime for which the individual is convicted, 2, the length of time since the commission of the crime, 3, the relationship between the nature of the crime and the purpose of regulating the occupation, profession, business, or trade for which the license, certificate, or registration is sought. 4, the relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the occupation, profession, business, or trade. 5, any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of crime to the occupation, profession, business, or trade. And 6, any applicable federal laws regarding individuals' participation in the occupation, profession, business, and trade. Do you all have, or would you like to discuss, I guess, on the record, where this denial falls under those factors and which facts using considering that?
Okay, board members, if you looked at number 1, it was the nature and seriousness of the crime. And that's what you need to discuss.
I feel like this denial falls under that for that reason,
Right.
based on the nature and seriousness of the crime.
Okay. Number 2 would be the length of the time. It's happened in 2018. If we discussed that,
Right.
I mean, this is what I was looking at. And then number 3, the relationship between the nature of the crime and the purpose of regulating the occupation, because this person is going to be a technician and it's going to be going into people's homes. Do you have any other that you might consider?
I think those 3 pretty well cover. He's got theft of stealing credit cards, driver's license, wallets, and as a person in the industry, you're in homes all the time, and somebody's wallet's sitting there on the dresser because you're working in their house. Well, the customer's not following you around. You very easily put that in your pocket.
Okay.
As a
How about
business
you?
owner, I would not want this gentleman working for me.
All right. How about you, Keith? You have an opinion on that? Do you agree with that 1, 2, and 3, or want to discuss any other ones?
I think that's got it covered well. I agree with it completely.
All right, Scott, how about you?
I agree. I think that covers it.
All right. And Lou?
Yes, I'm in agreement.
All right. All right, Keith, you want to make a motion that we're going to deny this application based on the Fresh Start Act, number 1, number 2, and number 3?
Yes. So do we need to get a motion for that or
Yes, I can't do the motion. You need the
Right.
motion.
Okay. We need to have a motion. We need someone to make a motion.
Yes.
I'll make the motion that we deny this application, the
Yes,
fresh
yes.
start on items 1, 2, and 3. Is that what you need?
Yes.
That's how you word this one?
Yes.
Yes, that's fine.
Okay.
This is where I'll second.
Lou, he seconded.
I
All
have a
right.
motion and a second.
All right. The motion to deny the application. Keith Harvey,
Aye.
Scott Cockcroft,
Aye.
Lou Richard,
Aye.
Doug Fraker.
Aye.
The ayes have it. The application has been denied. He does have a right to appeal, and we will let him know that process.
A letter of explanation would be nice. Yeah, you know.
Right, but we've already decided on it,
Right.
so.
Yeah.
But
If he reapplies.
if he reapply, yes, we would need some more information. And it does talk in here about maybe he's had some rehabilitation. That was what, number 4 or something like that. But he just did not provide it, so we had to vote on what we had in front of us.
Yeah.
All right, the next one is a person by the name of Soto. Going to work for a large alarm company, going to be in sales. We have a 27, it looks like we have a 2017 assault conviction, got 2 years probation. And you've got the documents here for that. And you do have a written explanation on this one. So this person to be 17, 18, and just now probably or barely just got off of probation. We're having a lot of difficulty trying to get a letter from the qualifying agent for these companies. You won't find any of that with these.
So do we know for sure that he's off probation or no?
No, so I don't know for sure. Let me look and see. Because it happened in 17. Let's look at the document here. See what it says right here on the report. It was actually on 4/18 of 2017, assault, unlawful force, violent bodily injury, 3rd District Court in Salt Lake, aggravated assault. It looks like it was reduced from aggravated assault down to assault, and they called it a misdemeanor, and he was convicted on 9/8 of 17. So 18, 19, he would be off probation. From the way I read the report anyway. Jesse, did you see anything else on there? That's all I saw on there.
There was the misdemeanor assault was what she was convicted
Yes.
of. And then there was a Class A misdemeanor, failure to stop at the command of law.
Yeah, I didn't.
Which I didn't see the date of that one though.
Oh, hold on. I might could help you there. Looked like it was in 10/29 of 17, failure to stop at command of law enforcement. Struck police, purchase, possess, consumed by minor, liquid, misdemeanor. Let's see if it goes down here. Other failed to stop. And this one is using nothing but numbers. but it looks like it was dismissed there on 6/11 of 2020. Dismissed with prejudice.
I wonder, because it shows on page 6, or sorry, page 9 of this criminal history, shows for that failure to stop at law officer. Plea date of June 2018. So I wonder if he had pleaded to some type of diversion or something similar to that, where he was on probation, and it may have been dismissed after that. Which, and this was, it says plea abeyance, so I'm guessing that may be. I'm not familiar with Utah's laws, but I think that may be what had happened. He had done some type of plea and it was dismissed if there was good behavior or something similar.
Right. It just according to the criminal record, also it's only one conviction.
Okay, and it looks like he
Mhm.
disclosed it in his personal narrative as
Right.
well.
He
So
did.
he explains that.
So that's the only thing that's on there. So he doesn't have doesn't look like he's got a history of violence. I think the screen's froze up, but we can still hear each other.
I can see Doug Fraker and Keith Harvey. Cody Vested
Yeah.
showing that you says
I'm froze. Yeah.
mhm.
All right.
That cold in Nashville, you froze? Oh, now she dropped altogether.
She may be trying to restart.
Mr. Harvey, would you like for me to pause the recording until Cody comes back?
No, we just keep going.
That's what I say. We can either, we can wait for her to come back, or I suppose if you all want to take a vote on this one, we could start moving through if there's more discussion or questions on this application.
Is there any discussion, or has anybody got any comment about this?
These are tough because he don't even live in the state. So is he going to be one of these that come in on the bus and then leaves? His mailing address is in Utah.
We don't know if he's going to be a central station operator or if he's coming, if
Right.
he's doing sales.
He's just a registered employee. So
That's what I say. This company is based in Utah, it looks like. So,
yeah.
If he's working in their central office, that could be why.
And that's one of those things. Okay, he's working in their central office, which has accounts in all 50 states.
Right.
We deny him. They're not going to fire him. It's just a fact.
Right.
Has anybody got a motion?
This is everything he did has nothing really that would not like the previous. If we're comparing the two, they're totally different from what I'm reading. So I'm going to make a motion to go ahead and approve this gentleman.
Okay.
Second by Scott.
We have a motion and a second to accept his registration.
So who can take roll?
It's Jesse's job now.
I suppose I can. Keith Harvey,
Aye.
Doug Fraker,
Aye.
Lou Richard,
Aye.
and then Scott Cockroft.
Yes. Aye.
All right, the ayes have it. So this one is approved. So we can move on to the third one. Cody Vest is trying to log back in. We should have more information on this, but this would be the Joshua Thomason application. And I have that it's a technician application as a registered employee. Looks like if you go to page 4, he does have an explanation letter he had submitted as well.
Jesse, would you like a copy of the TBI report?
Sure, that would be great.
Okay, let me send it to you.
Okay.
Hey, Jesse, it's Lou. I'm looking on page 5. From what I'm reading, he's still on probation.
Let me see. That might be true based on time. That's the way that I'm reading that.
8 years of probation.
That would
Yeah,
still be till
exactly.
2023. I mean, unless this doesn't necessarily show whether or not.
Hello.
There's
Can you
Cody
hear me?
Vest. She might be able to answer that better. Hi, Cody.
Okay, our whole server's gone down, so I'm calling you from my cell phone. I do apologize. Which one are we still? Are we still on, Mr. Soto?
No, that one was approved, and then now we have Thomason or Thomason.
Okay, who made the motion and the second for Soto? Remember?
I believe that was
Doug made the motion.
Doug, okay, and the second was
It was Scott.
Scott. Okay,
Yes.
to approve. Okay, so now you're on the Mr. Thomason. Is that the one you're
Yes.
doing now?
Yes.
Okay. The vehicular assault with a vehicle got 10 years, and now he's got 8 years probation, which I take it he served 2. Now he's got 8 years probation.
Mm-hmm. And that's what we were just discussing. Lou Richard had just asked whether or not this individual was still on probation. From what I'm seeing, that's what I believe. Do you have any more information on that?
No, let me see. It's hard to do this with your phone in your ear.
Right.
Well, he would, yes, it'd have to be because the sentence wasn't imposed until January the 21st of 2015.
Mm-hmm.
So he would still have to be on probation. I would think, because he had to serve 2 years
Mhm.
15, 16, 17, and then he got probation 17, 18, 19. Yes, he's still on probation.
Mhm. This one's, I haven't seen anything unless there was something that discharged probation for some reason, but I don't see that.
Yeah.
So I'm assuming he's still on based on the timeline.
And I looked at this, and he's going to be a technician as well. And in his orders, he's not able to drive a car. Defendant will not operate a motor vehicle. So if he's going to be a technician, I guess he'd be riding with someone else.
Well, it says will not operate a motor vehicle with passenger or other family members.
Oh, a defendant will not operate a motor vehicle with a passenger. Well, okay, misspelled that. That's fine. Other than okay, I read that wrong myself.
Yeah.
Good.
And it does say that he can only operate, if you look up on page 9, that he can operate a motor vehicle if it has basically a breathalyzer on it, for lack of a better term. It's a
Yeah, which will keep some company vehicles.
Oh, okay. This gentleman here, I don't know how we want to handle this, is ADT. So I think that's going to leave Keith out.
No, not
of
me.
voting. Oh, okay.
Now, Keith's ADS, not ADT.
Okay, I'm sorry. Thank you for
Don't-
correcting me here.
Don't
I
put
just
it
wanna
in
make-
big blue.
I'll forgive you
Okay.
once.
Thank you.
Any
All right,
any discussion or opinions on this one?
So I'm just curious. I'm sitting here looking. So main address, is that main address the business main address, or is that the customer or the applicant's address?
No, the main address is always going to be the company. The main address is in Utah. It's the company address.
So we don't know where this gentleman.
Is there another address in
Actually
Texas?
is. Yeah. I don't think I heard you.
I thought there was another address in Texas on there.
Yeah, there's another an address on there for Dallas.
That's why I'm confused on him being a technician in Tennessee.
If he was an operator, if he was working at a monitoring center,
Like we were talking on the last one, that's different. I'm just confused.
Okay, well, both of those are the company addresses. One's in Utah and one's in Texas. So he must be going to come in. He's going to be an alarm tech.
You know, I know we normally kind of frown on accepting anyone that's still under probation, and that is a pretty lengthy probation for drinking and driving for sure. But his description of what happened is pretty dang straightforward.
Yeah.
Yeah, I read what he said, and that's kind of like a strong sentence. But I do know Texas, I believe this is out of Texas. It's pretty strong on this. They have some hard laws.
For what it's worth, I wouldn't have a problem with this.
Okay.
Go ahead.
All right, gentlemen, do I have a motion?
Any more discussion?
So I'm a little confused how he would, if he is driving or not for work. Are they really going to put one of the breathalyzer things on a company truck for him to drive? Because if that's part of his probation, are they going to do that? That's why I wonder if he's not really in a monitoring center or something.
It's a good question. I think under his probation, if he violates it, that's issue for Texas, and him personally, not necessarily the company. But I would hope that they would put him in a vehicle where someone else is driving him other than, a family member, because it says a family member can't drive him, but he could ride as a passenger, if he's going with another technician. I would hope that they wouldn't put him in a position where they're saying, drive this car without a breathalyzer, but if he violates his probation at that point, that's really on him. We're not telling him that if this is granted that he's allowed to break probation.
Think out loud.
Well, my thought is to make a motion to grant his application with the stipulation that he can't drive for work.
Oh, Jess, is that something that we could do? To tell him how he's going to get back and forth?
And that's when say I don't know if we can. He's under a court order that tells him that he can't drive breathalyzer on there. We can telling and qualify it that if he breaks this. That's a good question.
But he is on probation. That's part of his probation, and typically we wouldn't even approve on probation. Aside from that, then I would deny the application based on probation and how recent the conviction was. I think, in some ways he's lucky that it wasn't more serious. Just the fact that, he only injured his passenger is what makes it sound less. But what if he hit somebody and killed somebody? It's really the same. It's the same crime, the same. I do think it's a serious crime or a serious offense.
I know that he provided a letter of explanation. Would it be something, because I know you all have asked the question about, is he going to be driving? Is he going to be in an office? Would you rather defer this and see if he would come in for an interview to explain what he would be doing, or see if the qualified agent would explain what he'd be doing, make sure that he's not violating probation?
Well, in the day where we were face to face, I think that would be much more relevant. I don't know about this video deal. How do you guys feel about that?
Well, just having a response, even if it is just verbal, but we could ask that they do appear on camera, but I think a response from them of what his job will entail. In the past, we couldn't ask that, but with some of the fresh start, I think it applies. We can consider what their job would be.
Oh, okay. Well, this is for a registered employee, so he's already on the system and he's already working. So you want me to ask for him to appear at the next meeting in February?
What's the other board members' feeling when y'all? Lou, you were alluding to the probation.
I think the bottom line is he's on probation. And this is, a more recent 2014. I'm going to make a motion to deny the applicant.
I'll second.
Okay, there's Lou and Scott to deny. All right. Now we need to take a look at the Fresh Start Act and put the numbers to it.
Do we need to do the roll call? Sorry, on the denial and then do the fresh start?
Oh, okay. I'm sorry. Yes. Okay. Motion was made by Lou and seconded by Scott to deny the application. Keith Harvey,
Nay.
Scott Crocroft,
Yes.
Lou Richard,
Aye.
Doug Fraker.
Aye.
Okay, the ayes have it to deny. Now we'll take it to the Fresh Start Act.
Okay. So now we're looking, in the consideration of denial of the application for any certificate or registration to an applicant, looking at 1, the nature and seriousness of the crime for which the individual is convicted. 2, the length of time since the commission of the crime. 3, the relationship between the nature of the crime and the purpose of regulating the occupation. 4, the relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the occupation, profession, business, or trade. 5, any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of crime to the occupation, profession, business, or trade. And 6, any applicable federal law regarding the individual's participation in the occupation, profession, business, or trade. So I think we'd start looking at number 1, the nature and seriousness of the crime. Is that one that you all are considering for this denial?
That's one I agreed on as you were reading them off.
Okay. Anyone else have number 1? Number 1. Okay.
Yes.
Number
Yes.
Okay. Number 2, the length of time since the commission of the crime. I think that
Yes.
goes back to the probation issue as well. You were looking at. 3, the relationship between the nature of the crime and the purpose for regulating the occupation, profession, business, or trade. Is that one that you all are considering? Is everyone considering that one?
Yes, since we don't know if he'll be driving, it does relate back to safety of the public. I would question whether or not the employer even knows about the probation stuff, because typically we don't send back the board, or the office doesn't send anything to the company. The company may not even know what his charges are.
Mm-hmm.
No, but they will get a copy of the denial.
They get a copy of the denial, but they don't get any copy of any. You said they do or don't get a copy?
They do get a copy of the denial letter.
It just says,
and the company. And it just says that you've been denied. We cannot discuss his criminal record with the company.
Right.
we don't know why you were denied. We just know you were denied. Because I had one.
Well, yes. I believe we're going to have to put wouldn't you think, Jesse, in the letter we would have to put why it was denied, wouldn't we? Under the Fresh Start Act?
I think because of the Fresh Start, we would. Mm-hmm. We would.
Yes,
so we looked at those 3.
Yeah.
Did you want to consider the other factors? Number 4, the relationship between the crime, the ability, capacity, or fitness required to perform the duties and responsibilities?
I think mark number 4 is one that we would use because of being out in the field, driving vehicles.
And then number 5 and 6, any evidence of rehabilitation is 5, and 6 is any applicable federal laws. Do either of those apply? Do you believe either of those apply?
I don't know if the probation would count for 5. I mean, he's still doing that. He's still on that part of it.
And as I said, there's not any evidence that he's, failed probation. I suppose you look at it that way. There's not any evidence that.
Right, that's true. Yeah.
So either way, I think that's kind of a could go either way. So what I'm hearing is that this denial is based off of the factors in the Fresh Start Act for a 1, 2, 3, and 4. I believe we need a motion that the denial is based on those factors.
I'll make the motion that we deny this application based on the Fresh Start Act of items 1, 2, 3, and 4.
Second.
A motion and a second.
Okay, that was Doug and Scott. Doug made the motion, Scott seconded it. All right, we'll do a roll call vote. All in favor? of denying the application under the Fresh Start Act 1, 2, 3, and 4. Keith Harvey,
Aye.
Scott Cockcroft,
Aye.
Lou Richard,
Aye.
Doug Fraker.
Aye.
All right, the ayes have it. The application has been denied. All right. If you want to now, we'll go to the last one that we have. This is going to be Miss Van Horn, and she is going to be a registered employee as well. And it said job title is secretary. Her husband owns this company. They have an office. She runs a small business, and he has his business, and they share a building, but there's a wall between them. Let me get over here. She was convicted of aggravated statutory rape. You have her lengthy description of the circumstances. Mr. Van Horn wants me to call him after the meeting to let him know whether she was approved or not. He is in favor of her getting a license, but he didn't give me anything in writing. It was just a phone call.
Is there cliff notes to this explanation?
I beg your pardon? I didn't hear you.
I said, is there cliff notes to this explanation?
No, you have to read the whole thing. Well, there really are. It's on. We have a woman that was neglected. A young man was hired to maybe cut grass or do yard work. One thing led to another, and he was underage. There you go, just cut and dry.
Gotcha.
She has nothing. Well, she did have a little. Let's see what else was here. Something about violation of probation in 15. The DuPont, yeah. But let's see, we had, what did we have there? Looks like we had 5 counts. Is that what you see, Jesse? Yeah, there was 5. 1, 2, 3. Yeah, 5 counts. She's convicted on 1. So she's going to be a registered. I don't know what classification a secretary falls under. You're not a technician.
I think this was the one. This is the one that you discussed where we discussed where the question is if she's a secretary, and I think she's doing some accounting work also, that she could have access to some records. I think is the best way to put it, that she could have access to some personal details and records of clients. So that was why they were asked to make this application. But I think she was mainly being brought in to do accounting, if I remember from our discussion.
You know, the problem that we have here, we've kind of got into some of this before, is we can't regulate those who are not registered, but, you know, it's her husband. She's going to work in the business. She's in the same office. She's going to help him when he needs help. That's probably going to be the fact of the matter, no matter what we say.
I think accounting too, you know, when Cody Vest and I discussed this, it could be something that they could do if the board did deny, you know, they could be explained what she could do that wouldn't require registration, you know, where she wouldn't have access. But I think the concern is if she's looking at account details, which in the business may have, that's where she was advised to submit this application.
Yes, and this is a small company. It's her husband and one other employee. There's the two of them, two employees, and she would be the third.
Yeah. This is kind of close to my area. This is a very small town. I mean, it's probably just a few thousand people. I mean, it's a small area.
Okay, well, let's take it. If it was denied, I'm trying to look over here at the fresh start what it would actually fall under. Oh well, number one, maybe two, length of time too. But what is the relationship, the nature of the crime, and the purpose of regulating the occupation?
Well, a lot goes back to what she would be doing, and she's not in customer homes. She's sitting in an office.
Right, I agree with that.
And what the brief summary that you gave me, I didn't read every word of this thing. I was trying to skim it, but having access to customers' accounts, she's going to have it no matter. If we deny her, she's still going to have access to it because it's her husband's business.
That's right.
So yeah, I'll commend them for even trying to register. You know, really, it's your wife. What are you going to do?
Yeah, she was, give you some more history. She was married to another individual, and then all this transpired, whatever. And then she married this gentleman, so he knows all about her past.
Right.
And he does want her to be employed with his company, so he's in favor of that. And like you say, she's just going to be, she has a little shop there, he has a shop, but for her to be the secretary and do the accounting, she would have access to information.
And I may be wrong about this, Cody, but this name I recognize. I think he's been in the business for a long time, hasn't he?
I don't have him down as being in the. I have it down as starting the company in 19, so it's a fairly new company. He might have been with somebody else as QA.
Yeah, I think he was. I think he was with another company.
Yeah, but he's just started his own company in 19.
I was just trying to read through the whole thing because I was trying to find out the time frame, and I think that at the very end she says it happened. It was 5 years ago, or over 5 years.
Yeah, 2015.
Yeah. I agree with you. I know your husband. He's going to be involved in the business. I don't think this relates to the job. I see that it's a serious offense, but I don't. I'm inclined to approve of.
Can we get assurance from her husband, the QA, that she will be an office administrator and not in the field? Can we ask for that from the QA?
Lou, let me ask you this: if that answer was yes, maybe she will be in the field some. With the type of crime that she committed, I agree with Scott. It's a serious crime, and we should take the whole thing serious. But is that relative to the work that she would be doing in the field? The type of crime.
Well, I mean, she's on the sex offender list, and I don't know if I'd want her in my house near my grandchildren.
Well, I guess I could see that. Yeah.
So, I mean, I don't have a problem with, if we can get assurance that she's not going to be in the field in customers' homes, either selling or installing or servicing, then I don't have a problem with this at all.
I guess all we have to go on is what they tell us.
Okay, we can approve her based on my asking the husband to give me a statement, even an email that says that she will not be going into the field and exactly what her position would be. Because he's already stated that she's going to be a secretary work and she's going to, which I assume probably answering the telephone or whatever duties that is, and she's going to do their accounting work. And she's going to run her own little business there too. Doesn't sound like she's going to have much time to get in the field, but I can do that. And if I get that letter, fine, but I don't, or we can hold it off till I get that and then do the February meeting, however you want to handle it.
So that statement that she's going to be in office administration is somewhere in this letter. I'm trying to skim.
No, I don't. Hold on. Apply for the application.
I don't believe she puts that in her letter.
No, all she says here is that she's applied for the application. They're trying to do everything by the book. He started the alarm business. She has a bath and body product business, and we'll be creating a 2-in-1 store. That's what they said. They had a wall between them. So she's going to be starting her own business too.
It sounds like she's just going to be at the office from the description, and it sounds like they're trying to do things right. They're trying to get her licensed just to clear up any appearances of impropriety. Because you could argue that she doesn't have to be licensed to do accounting
or be a secretary, I guess.
Right.
Secretary might.
If she wasn't confidential, passwords, call lists, all that stuff.
Mm-hmm.
So I would be inclined to approve with that stipulation that it's just administrative. So I guess I'll make a motion to approve with Cody getting a stipulation or a letter that she would just be working in the office or working administratively for the company.
From the QA, not her. I'll second that.
Correct.
From the QA is her husband, so.
Yeah.
I understand, but.
Okay. All right.
I understand.
So do we have a
second?
second?
Do we have a second?
Yes, Lou, I second.
Lou.
Okay, we have a motion and a second.
All right, we have a motion and a second to approve the application with me asking the husband to give me a statement that says she will not be in the field. She'll be working in an office or however he worded that. Keith Harvey.
Aye.
Scott Cockcroft.
Aye.
Lou Richard.
Aye.
Doug Fraker.
Aye.
Motion carried. She is approved. All right. Looks like for the criminal records, we had 2 denied and 2 approved. All right. I think let me close all this up. I'll get it all dirtied. All right. I think what I have next is the education. And I think everybody's got their documents. Let me go down this list here. Lou, let's take you first. You had the Alarm Monitoring Services Incorporated, marketing and advertising for all employees for 2 hours of continuing education.
No, I had AMG Uniview Tech. And if you want to skip to those, I'll go ahead and make a motion to approve both those courses for 2 hours of continuing ed.
Okay, I'm sorry. Maybe I read the wrong thing. Who's talking? I can't see who's talking. Is this Lou or Doug?
Lou. Yeah, no. I was given AMG Uniview Tech 2 courses for 2 hours continuing ed, and they both look great. So
okay.
I'm going to go ahead and make a motion to approve AMG Uniview Tech's 2 courses for 2 hours of continuing ed each.
Right. That was read the specifications before installation, and the second one was surveillance in and end-to-end world. All right. If we want to, we can wait and take a vote at the end of the discussion.
That's fine. If
that works.
Okay. All right. So we're going to withdraw that motion. Okay. Now, Doug, you did get yours, right?
Yes, I had the AMS.
Okay.
And both of those courses are fine for 2 hours each.
All right. And I think I already read that, but it's alarm monitoring, marketing and advertising for all employees. And would your business survive if? All right. Scott, you got 2 of them also from Security Solutions.
for Alua, and those are is that Dawu?
Dawa.
Which both of those look good.
All right. And so that's
continuing ed for the
1 hour.
1 hour.
Okay. Is that pronounced Dawa?
Dawa.
Okay. Dawa. Leveraging your surveillance systems with video analysis and low light video solutions for those. So Keith, you had 2 also.
Right. Tech services, two separate courses here. Although they're 16 hours, although both courses were great looking courses, they have absolutely nothing to do with our industry. Basic electronics and basic fiber optics, good information, good course, but they're asking for everything on this. And I think it would be good for continuing ed or employee training, but not initial app. There's just very little to do, if any, to do with security or our industry at all. But although basic electronics and fiber knowledge would be good to have and they're good courses, I just don't think they're good for initial app.
Well, this is going to be for the qualifying agent. Okay. So we can approve that with that stipulation. Okay. If we're ready to, we'll take a vote for the alarm monitoring course that was approved, the AMG course, those 2 courses, Security Solutions, 2 courses, Tech Services, we're going to approve the 16 hours for employee and for CEUs only, and not for initial. Do we have a motion here?
I'll make a motion to approve these courses.
Okay. Who was that? I'm sorry.
God, I was trying to make a motion and we did it the same time, so I'll be the second.
Okay. Approved all the courses, 1, 2, 3, 4, 5, 6, and those 8 courses are approved. All right. And let me get a roll call. Keith Harvey.
Aye.
Scott Cockcroft.
Aye.
Lou Richard.
Aye.
Doug Fraker.
Aye.
All right, we got those all finished. All right, that's the education. Don't have any courses up for review. I don't have any unfinished business if the board members don't. I don't have any new business to talk about right now either. And I believe all to be left would be adjournment then.
Okay, we'll call this meeting adjourned.
No, I have to do roll call.
Oh,
I get a motion. Yeah,
Or we hang up on you.
yeah. I gotta have a motion here and roll call.
Motion to adjourn.
That's Doug. Okay, second.
Second.
Secondly,
Lou. Okay. All right. We got a motion and a second to adjourn at 11 o'clock today, December the 17th. Here's a roll call. Keith Harvey,
aye.
Scott Cockcroft,
Aye.
Lou Richard,
aye.
Doug Fraker.
Aye.
Pardon me. The ayes have it, and we are closed. We are finished with the alarm meeting. And I do apologize for this computer is still froze up. So we're going to have some problems today. But gentlemen, I hope everybody has a happy New Year. I mean, Christmas and New Year, and everybody stays healthy. We will be talking to you as soon as I find out anything about the legislation or anything. So everybody have a nice one.
Merry Christmas.
Everybody,
Okay.
Merry Christmas.
Merry
Happy New
Christmas.
Year.
All right. Bye.
Bye.